unmute myself. For some reason, I lost connection, but I'm back. So saying, please come join. We are live. Join. So I'm gonna begin speaking in about 5 minutes. Technology. Let's see if I can turn the background. Oops. Okay. All right. So I'll try to see who's welcome to our weekly update. So I'm trying to follow. Trying to follow. I hope you can see me and also see the PowerPoint presentation. I was saying like today we have prepared you, my team and I have prepared a PowerPoint presentation so you can read as we discuss. I also mentioned that, and sorry, I think I have a good lighting. That's okay. I also mentioned that some of there are new updates, you know, there might be new updates since we prepared this PowerPoint presentation. So I will try to go over a few of those. Yeah, so I will get started, and as people join, you join, and also this video will remain on our Facebook page, so you can go there and watch. If you were not able to follow us. Okay, and I begin, and also, like I said, I may have some new updates for you as we speak. By the way, the Vice President of the United States, Kamala Harris, is visiting the southern border between Mexico and the U.S., you know, especially Texas and the U.S. So I'm sure there will be news from that trip, but also there are some other news that I got today that will not necessarily included in the PowerPoint presentation that I will discuss. So first, as you know, my name is Claudine Umuhire Gasana. I'm an immigration attorney. I have my firm. It's called Gasana Law Firm or Law Office of Claudine Gasana. You know, we pride ourselves for integrity, experience, and dedication. So that's really our motto, and we abide by it. Our clients appreciate our efforts and our dedication and our experience. I've been an attorney for the last 10 years. Yeah, time flies. Since 2011, actually in June. So 10 years of experience in practicing immigration law, 100%. Immigration law is a broad range of areas, really. So, you know, some people may have a perspective or an understanding of what is immigration law, especially what's, you know, maybe portrayed in the news. But immigration has different aspects and different you know, I guess areas of, I'll not say specialties, but you know, there's a business side of immigration. There is a family side of immigration, there's investment, there are skilled workers, and there's also the humanitarian side, which is usually mostly in the news because obviously it is more sensitive, like human rights involved, and that's why like the updates or the issues. Well, actually, the issues at the moment, or the crisis as they call it, is basically regarding to asylum seekers, asylum and detention, people who are detained, and the people who are coming at the border, and how um, the system is overwhelmed. The courts are crowded. So, but there are so many aspects of immigration law, and we will continue today. We will give updates. I would like to give more updates, or more to discuss more topics as we keep going. I have prepared the different PowerPoint presentation that I will present to you in the next future. So we discuss of the new program, which I was excited about, but now I'm not sure if I'm excited about, given the um, the uncertainty, and I guess lack of practical, like how is it going to be put into effect. That's the international entrepreneur parole. I think I spoke about last time. I have a PowerPoint that I will present to you next time. And we'll also talk about the national interest waiver. And lately I have been dealing with detained cases, how to interact with the CBP, which is the Custom Borders and Protection Office, and ICE, which is Immigration Customs Enforcement branch. It's like law enforcement. How it's interesting. So I really want to prepare another presentation on that topic as well. As we speak, actually last night I really was dealing with the CBP officers who were, did like trying to, I don't know if it's a lack of training or something, but like detaining individuals, even lawful permanent residents, for false reasons or for like misapplication of the law. So many things are happening, and when you don't have an attorney, someone may be detained for days, for weeks, or months, with nobody looking, like no action being taken. And that someone could be a lawful permanent resident, a legal permanent resident, or even sometimes we hear citizens being detained for weeks and months. And that's really like their rights are not being respected. They are being held against their will. They are being held in a wrongful manners. So I will prepare something about that, and to awareness of people. You travel, you think you have a green card, so can travel and come back. Sometimes you may face issues, be forced to spend a night or two in detention or holding cell at the airport for a misunderstanding, or like maybe a misapplication of the law, or confusion. So those are things we will I also want to talk about, because someone who comes here is an asylum seeker. They are processing, they are put in detention. 1 month passes, a second month passes, and that person has no one came to tell him what's going on, ask him why he's here, give him an interview to see if he qualifies for asylum or not. But he or she's being detained until she's lucky an attorney intervenes. And when we intervene, of course, everybody wakes up and everything is sorted out and the person is out, right? Because you cannot detain a human being without due process. They have a due process rights. They have to, if they have a claim, there's a system, there's a way to address the claim. If they pass it, they don't pass or the interview, then there's the second or the next step to have a judge hear their case, and then if the judge says yes, they go through the whole asylum, which we talk about in a minute, how the process is going to be easier or on both the government and the asylum seekers. But what I'm saying is, like, the government cannot detain anyone indefinitely without going through the process of, or like, you cannot hold anyone indefinitely for no reason, or without hearing their case and allowing the person to make their case, and for the case to be heard, and asylum granted or denied. Yeah. All right. So now, those were the comments I had to make, like, or other topics I'm planning to talk to you about in the future. So now let's move on our first topic of today. So the first topic today is that the Attorney General, Merrick Garland, he restored the asylum eligibility for victims of domestic and gang violence. So this is, so when an Attorney General, because I think we discussed one of my presentations in the past, that the Department of Justice, the immigration courts are under the Department of Justice umbrella. So the Attorney General is the boss of immigration judges. So the Attorney General can usually, by law, if a case has been decided, the Attorney General can refer the case to him or herself to review it and reverse the decision that was being made, or change or amend or set a new decision, which is what we call a precedent. So in law, we basically base most of, especially in the United States, legal precedents have, that's what a claim, when you in any type of law, there are legal precedents we go by to assess a situation, or to make a case for any claim. For in immigration law, there are also precedents. So the Board of Immigration Appeal usually sets precedents, or if a case move forward to the federal court, the circuit, we have different circuits in the United States. Circuit set a precedent for the region under which the applicant lives, and in the end, the United States Supreme Court sets the final precedent. So in cases where the case has only reached the Board of Immigration Appeals, and the Board of Immigration Appeals sets a precedent, then that case is usually, the law of the land, if I may say, the law, until that case is challenged in the federal court, although it's the Supreme Court, or until the Attorney General, under certain circumstances, may refer a case to him or herself and redress or update or amend the precedent. So in this case, in these two cases, matter of AB and matter of LEA, so basically the Attorney General Sessions, I think he's the one who got rid of, I didn't mean to do that, of matter of LEA, and then Attorney Barr, I believe, he changed the matter of AB. So what are those matter of A, B, A, C area? So I don't want to annoy you. So basically, these cases is it says in the on this slide were concerning the victims of domestic violence or gang violence, and most of these were these types of cases come from the Central and South America. You know, most of I don't know if it's most of them, but a handful, majority of asylum seekers coming from those countries flee domestic violence and gang violence. Um, so, so what these cases did, it basically the attorney generals in the last administration made it harder for victims of domestic abuse and gang violence to seek asylum based on particular social group grounds. So in asylum, there are different grounds of seeking asylum, and particular social group is one of them. So these decisions, that the previous attorney general made, when he got rid of the matter of LEA and also complicated matter of AB, he basically it really gave brought confusion in the figuring out how to qualify a victim of domestic abuse or gang violence under the particular social group. It's a different legal terms like nexus or not incident, like the abuse should not be incidental. It should be the central of reason of being abused. So that those are like legal terms, but to kind of not go into I guess boring you, matter of AB and matter of LE, the the Attorney General Garland has redressed the issues. Like it's gonna be easier, not easier. It's going to go back to how it was for victims of domestic violence and gang violence to qualify for asylum under the ground of particular social group without stringent requirements or without restrictions on how to prove that they are a part of a particular social group. So and then seek asylum under that ground. Next is right. So the Biden administration is proposing big changes for immigration law. So there are new changes that they seek to make. There's a proposed regulations which will be included in the spring regulatory agenda, which, as we have discussed, the president does not make laws. The president implements the law, which means the president sets up regulations or mechanism to implement the law, because most of the time when the Congress enacts a law, the Congress gives a big picture, like gives I guess sets the big picture of how things should go. Like, this is the law, it's asylum law, who is eligible for asylum, what are the grounds to seek asylum from, or when to seek asylum. And then the executive branch put into action how that law is going to be implemented. So that's in this umbrella that the president can go ahead and make different changes or regulations. That's what happened with the previous president. He made so many executive actions in regulations that actually I think they say it's 400. So the same Biden administration is proposing changes to which will be more friendly to immigrants. So some of the changes will include DACA. So DACA, the deferred action for childhood arrivals, DACA, still today has not been put in front of the Senate to be to become law, so that this group of people, over 100,000, will be protected. So the Biden administration we set a policy that we protect and fortify the DACA initiative, so that if another president comes into, another president or another administration comes in, we not be able to change or to remove DACA easily as it was before. So they plan to on publishing the new DACA regulation for notice and comment in August. So we are yet to see what will what will for fortify and protect DACA. We are yet to see it. So that's what they are planning, so that even in case the Congress doesn't protect DACA, doesn't put DACA, in law, like, so that it's a law of it's Congress. When a new president comes, they will not be able to get rid of it, unless, of course, they really get in front of the Supreme Court, which is not going to be easier. As we remember, the DACA case went all the way to the Supreme Court, and the Supreme Court left it as it was, and instructed the previous administration to actually have Congress enact the law that will protect these 800 young arrivals. So the Biden administration is planning on implementing regulations that will protect and make it strong, so that a next president or a next administration, if it's not an administration that supports DACA, doesn't come and change it and put it in jeopardy again as it was in the last 4 years. Or actually, it's been so many years. DACA has been through courts for a long time, since it was enacted. I mean, actually not enacted, since it was put in place. So another big change to be made by the Biden administration is to public a new public charge rule to replace the Trump administration's overturned rule, which required new immigrants to demonstrate their assets and worth. So we spoke, I believe, that there was a public charge rule that was set up by the previous administration, which required an additional documents from anyone who was immigrating in the United States to provide to prove really that there will not be a public charge. The public charge is one of the grounds of inadmissibility for anyone who's immigrating in the United States. Basically, you have to show you not be the burden of the government. So if someone petitioned for a family member, for example, and you are a U.S. citizen or a lawful permanent resident, you have to, there's a form usually that's an affidavit of support. You have to show you earn beyond the poverty level. And that's the requirement. Your earnings are above the poverty guidelines, and then your relative comes in the United States. But the public charge rule that was in place last year, it was there for like a couple of years. It required the immigrant, the intending immigrant, to provide the credit score, to show they have a health insurance, to show they speak English, or they have a language skills. So the public charge rule was beyond what it should be required for anyone intending to immigrate. And in the United States. And it was also extended to non-immigrant statuses. For example, someone with who's applying to change status in the United States to a student visa, to extend a visitor status, to change to a dependent of an L1 or H1, they were required to answer questions to show that they will not become a public charge. And if they answered some questions in positive or in affirmative, then they will have to show that they will not be a public charge. They will have been required to complete a form. The form was Form I-944. It was a long form, 20 pages, and you had to comply with so many documents. So this public rule is no longer, because the Biden administration overturned or ended it, but the Biden administration is intends to publish a new rule. So we, stay tuned. When we learn more about this new rule, we will let you know. Right. So there's also changes in the fee schedule. So I guess actually it used to be every few years, the USCIS, which is the agency in charge of immigration matters in the US, changes the fee schedule. So they usually increase the fee schedule. The last administration had proposed to increase fees ridiculously, but the rule or the policy was overturned by a court, a federal court. So now we still use the same fees, but the Biden administration they will propose changes to the fee schedule. We hope they will not increase the filing fees, because in the fee schedule that the previous administration had attempted to put into effect, the citizenship application, for example, will have almost doubled the filing fee. The filing fee at the moment, I believe, is $680. Don't quote me on that. Sometimes I don't memorize, but you have almost doubled. It was going to be over 1,000. So now we hope the new fee schedule will not be ridiculous. This is not the time to increase filing fees when everybody's coming out of the pandemic and people are trying to put their lives together. Okay, so another proposed rule will allow U.S. consulates to waive in-person interview requirements for selected visa renewal process during the pandemic. So as we know right now, most consulates, they are not open for interviews, especially for non-immigrant visa interviews. They are open for family, family immigration, like a marriage petition or fiance visas, and other petitions. You have to show some type of emergency. So so there was a practice of where, like, now the Department of State is allowing people not to interview. They just need to file an extension. If you previously had a visa and you are applying under the same visa category, they will waive the interview, and then you will get your visa, I guess, in the mail, or you can just drop your passport. So the Biden administration is proposing a rule that will allow the U.S. consulate, like if someone is applying for a visa and it's a renewal of an existing visa category that person was approved initially, then they will be waived an in-person interview. That's going to speed up the process or in the backlog, because even if the immigrant visa, like family immigrant visa, have been have started to be scheduled, we are still seeing a backlog months and months before our clients are scheduled for an interview, and you see families are forced to stay apart from each other because of that backlog. So we hope this is gonna help, especially that during the pandemic, I don't know how many consulate have reopened their services, but I don't think any has reopened on 100% or fully reopened, because of the pandemic. Okay. Yes. So now there are changes to the asylum process, or to asylum processes. The Biden administration intends to make some major changes. When I began, this video, this live, I was talking about how I have been dealing with detained cases in the last few weeks, and how I have realized so many issues in that area. And so these changes that will really help with the issues. So I mentioned how I have been getting calls from the people detained at the one of the Texas detention centers here in Texas, at the border. And you'll be surprised to know that someone calls me and tells me they arrived in the US 2 months ago, 3 months ago. They are in detention. They haven't been asked anything other than just the first interaction with an officer when they were apprehended. They were put in detention, and that's it. And then it's been 2-3 months, no follow-up. They don't know if they will be if they will have a chance to plead their asylum case. If they, that's usually what's called a credible fear interview. They haven't had a chance to have a credible fear interview. So which is an interview they have with an asylum officer. And when the asylum officer say, a credible fear means, okay, there's a significant possibility you qualify, you may have an asylum case. Then the case move forward. The asylum officer issues a notice to appear, and then you'll be scheduled for a master hearing before an immigration judge. And when when you're waiting for that to happen, usually, especially after the prosecutorial discretion, we spoke about a rule we spoke about last time, then you are allowed to wait outside, not stay detained. They have a way to track you that you have, so that you answer to in your court, in your hearing before an immigration judge. And if you don't pass that credible fear interview, you have another chance again to go in front of an immigration judge, and an immigration judge will either affirm the asylum officer decision, saying like, oh no, I don't think you have a claim, or they will vacate the decision, and again you go into the removal proceedings so that you can plead your case further before the immigration judge. So that is a problem, like I said, because people are being detained. Obviously, these officers, for them, they are overworked, they are overwhelmed. So they just maybe, I don't know what is the screening process. I cannot speak for them, but the matter of the fact is, there are so many people detained. They haven't had an interview. They haven't, been scheduled before a judge. So what these new changes or asylum changes to the processes will do so the administration will issue an interim final rule, which will allow asylum seekers who pass the credible fear interview to be sent directly to the USCIS asylum office. They will only go to an immigration judge, before an immigration judge, if they were denied asylum by an asylum officer. So let me tell you why this really is a good idea. It's because, we spoke in the last presentation how the immigration courts, they are already crowded. Like they have so many cases. Here in Houston, it's not even Texas, Houston, Texas, one city in the Texas state. And the non-detained docket, we have two dockets, non-detained and detained. The non-detained docket, last time I checked, they had more than 70,000 all cases pending before an immigration judge. And the non-detained docket has been closed since the pandemic. It's reopening on July 6th. So that means if the credible fear interview cases are not to be reviewed by an immigration judge, instead they will be reviewed by an asylum officer, that will free the docket of immigration judges to review those backlogged cases. And hopefully this also will speed up the case at the immigration asylum offices. So actually I was, I told you in the beginning, like when we prepared this PowerPoint, new news came up, because there's always something new every day in immigration law. So I actually have, some other news. Okay, so I'll have some more statistics about the backlog in immigration courts. Okay, so according to Syracuse University's transactional records, right now, because of the pandemic, only this fiscal year, so the data shows 126,911 new immigration court cases were added to the for this fiscal year, and only 68,260 cases have been finished. So this fiscal year, which is 2021, yeah, fiscal year started October 2022. Like this half, really, in half, we are almost half through this year. Almost 127,000 new cases added in immigration court to the docket, and only 68,000 cases completed. So, the total of backlog cases is now 1,337,372 cases before immigration courts. So I don't know how many judges. And the fun thing is, during this year, the Biden administration only hired 12 judges. So imagine 12 new judges to how many judges they have to tackle the new cases, 129,000 new cases this fiscal year, and the total cases of 1,300,000 of cases. So, the fact that now with the new rule that, so basically when someone comes at the border, they claim they have an asylum case, they fear for their, that they are seeking asylum under the protected grounds, and an asylum officer says, yes, it seems you may have a case. Instead of sending them in front of the judge, the same officer will now review their cases. Now, we can also, next time maybe I can put up the cases that are still pending before the asylum officers. They also have a lot of cases pending right now. As a matter of fact, we have cases pending since 2015 that have yet to be interviewed, initial interviews. So that's also gonna add another problem, but I guess they will, at least they will not be detained. I hope they won't keep them detained for the time that the asylum officer is reviewing their case. And I hope also their rights will be protected. That obviously, even if you have so many cases pending, the rights of asylum seekers, the due process rights, and the right to be heard, they should be also respected. Like we don't need to rush into finishing the cases. Like they have to be given time and all that's needed to plead their case and the case to be heard. So yeah, but that's a change. Hopefully it's going to make a difference, and hopefully they will also hire more asylum officers to deal with these cases, because they already deal with so many cases. So another big change coming is that the administration intends to align its I guess its guidelines with the current international law, like what is the victims of gender-based violence to align with the international law, or the Geneva Convention, or how UNHCR determines what are the protections for victims of gender-based violence, because so often we actually rely on the UNHCR guidelines on some of the asylum laws or asylum precedents, because there's no really there are no detailed regulations in terms of some of the protected grounds, especially the particular social group in the work, what is comprised among the particular social group, and how the victims of the gender-based violence fit into all those protected grounds, because sometimes you could be a victim of gender-based violence, you could fit under the ground of political opinion, like if you if really you are an advocate against the domestic violence or gender-based violence, you could be viewed as a political opponent. So that's part of the ground. You could so under the ground of political opinion, but also again, like as we explained, the particular social group. So if they can, it will be a good news if the administration can set up rules that will align or will explain or expand or clarify the protections for victims of gender-based violence. All right, and also as we spoke, there were so many regulations in the last administration, 400 if I may recall, or even more, 1,000, I don't know. So they plan on rescinding several Trump-era regulations, which are currently blocked in court. So yeah, like there are so many regulations that were really blocked by federal courts because they were against so many against the Constitution, so many rights that like basic human rights, due process rights, and anti-discrimination rights. So there are so many Trump-era regulations that are still pending before courts. So the Biden administration is planning to rescind these regulations. So in that case, then the cases in front of the court will be moot. So then there will no longer be an issue. All right. Right. So one good news, actually major good news now. So there's this type of visa. It's called U visa that protects victims of crime. But the U visa right now, petitions, they are backlogged. It takes over 5 years to get a U visa petition approved. So now, and then the petitioners, they are pending, they don't have any, they are waiting for all those years. Now what the administration is planning to do, they are planning to give a preliminary, like a bona fide or prima facie the determination of pending cases. For example, a U visa petition, you so you are a victim of a crime, and then you report the crime and you help the authorities to solve the crime. So once you have a certification from the authority that yes, you have solved a crime, and and your involvement, usually you should have like a prima facie or bona fide determination. So, but it's not determined um, until you are approved. So now what the government is planning to do is to provide those determinations, like to review pending cases and see which ones are more likely to be approved or have obtained certifications, and then issue work authorization to the petitioners while they wait all those years for the U visas to be adjudicated. And also, that will also give to their qualifying family members who are the spouses and children under the age of 21. So that's good news, because U visa petitioners, they wait so many years, and after going through the trauma and helping, like because they are helping the government to solve a crime. So that's the benefit they will get. um, so that will help to be able to work, like as we spoke in the last time. The employment authorization is not only for working. So in states where you need to drive, like Texas, it also gives you an ID, photo ID. You have a driver's license. You can work, and you can be a member or productive member of the society. So that's going to be a very good news, although there are so many cases pending, a lot. I thought I have the many hundreds of thousands, or if it's 100,000, but thousands more pending. So I don't know how they will go through each case and how often or how fast they will issue these bona fide determinations. They, according to the rule, or the rule, I guess, guideline, the administration with the applicants or the petitioners or the attorneys don't have to do anything further. We will receive in the mail a notice that you've been certified, and don't know if they will approve the work permit right away, because or if they will require to apply for a work authorization. As more details are obtained, we'll keep you updated. That this will keep you coming back every 2 weeks to watch what's going on. Oh, actually, I have it. The process. Okay. Right. So the immigration will conduct initial review of these petitions with the I-918, and like I said, they will issue bona fides. So USCIS will issue EADs. They don't the employment authorization documents. There will not be a need to apply for the work permit. Those who do not receive the EADs, of course, they will be placed on the U visa waiting list, and maybe they will be required to provide more evidence when it's time to process their cases to show they qualify for the U visa, which will again takes more than 4 years. Yeah. Right. So yeah. Always, I guess we have become a broken record. There should be a way of building a better immigration system. There are still many problems within the U.S. immigration system. These proposed changes may take months or even years. Well, they may not take years to go into effect, actually, to make a difference. So it is hopeful. It's better than nothing, and hopefully this immigration problem or issues will be resolved. But whatever they give us to help us better the lives of our clients, we will take it, because obviously it's a bigger program that like than individual cases or individual actions were fixed. So we're hoping for a better immigration reform, and immigration reform that will look into more than fixing like what's in front of us, but also looking into the problems that lead people, for example, to flee their countries and come in the US. Because most people, nobody really, like, if you put yourselves into the everybody who's risking their lives will put their lives up in so harm ways if they don't if they had a choice. So most of them don't have a choice. That's why they come. So hopefully, I'm sure the administration, the governments, they're working on it. But in the meantime, we really hope these solutions will at least alleviate some of the problems, some of the issues, that are currently happening. Right. Okay. Thank you for watching. So I will invite you guys to subscribe to our to our YouTube channel, to Instagram. I also have like a new Instagram now, Claudine Official. Sorry. And then on LinkedIn, on Facebook, of course, if you are, I was hoping to also, I guess, stream live on YouTube. So, anyway, follow. So I made it a plan for me for my team and I to have these bi-weekly updates. I hope they help you guys. And should you have any questions, I'm checking on Facebook to see if you dropped any questions. Questions. I guess no. Oh, okay. Hi, Celine. Thank you for watching. Oh, okay. Hi, Celine. Thank you for watching. Turn this off. Working different technology at a time. All right. So, I hope this helped. And please subscribe and follow us on YouTube. Immigration Lawyer Claudine Gasana. That's the YouTube channel. Trying to grow it. So follow, subscribe, so we can post more, more updates. Like I said, in the future, we will not only talk about this. For some reason, I do prepare to speak about another topic, but then these new updates come, and then I'm like, you cannot have to talk about them, have to focus on them, especially since today, this couple of weeks, these new changes on the asylum processes, the U visa petitioners who will receive work authorization, other updates are coming, the new public charge rule, and all other topics we talked about today. Those are very important to pass by. So new updates come every day, every week. So next week we have something good coming. Like I said, I want to speak about the International Entrepreneur Parole Program. I will talk about the benefits and actually the mishaps. Like, I don't think it was thought through in terms of who can qualify, who can apply. What is it? It's not a status. It's not a status. It's a parole. You can't change status in the US. You have to go abroad. You cannot change to anything. So, well, we will discuss about it, and then I will say, okay, what's good about what's the opportunity for that parole, but also what are the cons? Like, is it worth it? So that we'll talk about that in our next biweekly update. And the national interest waiver, which is a program or a benefit that it's not known, and it's really beneficial to so many people who are very knowledgeable with expertise, different types of expertise. It doesn't have to be only science or engineering. It could be culture. It could be business. It could be technology. It could be someone who's very crafted. As long as you show some, like you really will be in the national interest or like prospective impact or actual impact or past impact. All right, so now I'm gonna let you go. I am